Council of Governors of the Kenya Medical Practitioners and Pharmacists Union. But I can't see the council. Can we have room here so that I can see the court? The parties who are present in this case, can I hear you? Morning to you.
I'm holding brief for Mr. Masise. For the claimant third respondent.
My name is that matter, Ms. Akuna. I do appear for the Cabinet Secretary and the AG.
Can
My name
we have the councils appearing in front? Please, the members of it's the court, not the council.
Yeah. Sorry, my lady. We're trying to have a bit of a discussion. Co-counsel versus what?
Yes. Let's take the program first.
Is it which needs to find it?
The Council of Governors.
My lady, the matter was Shika. I appear with Mr. Mutula Kilonzo and Mr. Cheng. We appear with the union.
My name is Mala Siris. I appear for the claimant, applicant, the Council of Governors. Although our senior Honorable Mutula is here appearing, the respondents, we have not been served with any notice. But that's neither here nor there.
I appear in my capacity as an officer of the court. Allow me to wish you a happy new year. I don't know if I'm an officer of appointment in the matter. And then we are appearing together with my colleagues.
And I will let you sit in as a member of the court. Yes. Because we still don't have a lot of people. Okay. Mr. Washington.
Yes. My lady, we filed an application on the certificate of agency on the 24th of January. My lady, it was placed before you yesterday. Hearing to such by that. My lady, we served all the parties with that application. We are ready to proceed with that application. It's an application for review of the orders of the 12th of January 2017. We are ready to proceed.
Since I saw you in, but Mr. Nyiru was holding a brief.
Yes,
Can you
yes,
report address the court?
I'm not present.
Yes, Mr. Masese.
In response to
What Mr. Shika said.
about this application. I was served this application yesterday, and I didn't have an opportunity of going through it because it was late in the evening. But I've just seen the kind of orders they're seeking now. And my lady, my worry in this one is one. I'll address it first from the professional point of view as an advocate of court, that at all the time we owe these courts our allegiance and we must advance our clients according. That's the first duty of an advocate to this court. And secondly, Lady, we are not saying that parties should not negotiate. The essence of all this process is about finding an amicable solution. But it comes a point where parties cannot negotiate when guns are held in the heads directly. Well, Lady, we have come to this court on several occasions, indulged the doctors, the councils. We have sacrificed our time in terms of having meetings to discuss this issue. This application, if I have to make a response to this application, I'll say that the application is not honest. To be very honest, the application is not honest. Because, one, it's a very simple issue. The tactics of negotiations, techniques of negotiations, when it comes to collective bargaining agreements, terms and conditions are known. We cannot have the court indulging both parties to sit and agree and come, because it's not the court's business to put doctors in jail. That's not the business. But the court feels like the orders it has issued are not being obeyed. And then now we have this application again without giving an explanation. The level of where have we reached in terms of negotiations? What can we report to the court? Do we have anything to report that yes, this is the last time we sat with the minister, and this is the extent, right? And we were open to this and that. Then, my lady, from there, you can also be able now to understand and say yes, there's a way I can make an application to review my order. But without that guiding principle, my lady, you cannot act just without something guiding you to review the orders. Because right now, it means we are now moving from that aspect of industrial relations. Now we are going to argument of legal arguments about the content of court proceedings. I don't know what.
I see you getting into the merits of the application.
Yes.
But stop you from there.
Yes.
I thought you tell me on the staff, you want
Yeah,
them to respond.
I have to serve the application. My colleague is ready to proceed the application that you say. We can, the thing is, we are going to be told, find your responses. That's the process of the court. And the first process of the court must be paid also before we are told, file your responses. We are ready to file the responses, but first thing is obey the first court orders that were issued, then we file this one. Even if it means for a month, then we go back to the strike. I mean, that is, it serves both parties. That's exactly what I was having to say.
That is Mr. Masese. Ms. Akuno.
We have not been served with the same application. But on the face of it, I would associate myself with the submission of my colleague. Would be objecting to the same application on the grounds that the applicants have not demonstrated any seriousness in this matter. The strike is still on. They want a review. So we may be, as we will be granted the time to file our response, we are totally opposed to the application.
My lady, I must say that we were served yesterday, in the evening as well. And under the new Contempt of Court Act, when you look at section 32, the said section allows this honorable court to section 32. It does allow this honorable court to review its orders. But the orders we're talking about, my lady, are discretionary orders. And even as I was coming here, I was pained with the thought of what we see the judiciary as. The judiciary has to be such a firm place of refuge, a strong foundation where we come for orders, where we come for orders to be reviewed, so that if they get their right and their day in court, we should also be in a position to obey those orders. So even as much as, and I've looked at the application, that the law allows you to review that, and we'll be hoping that if you're minded to use your discretion to review the orders, you might even review them to increase the severity, for example. Having said that, I do believe that they have a duty to demonstrate what it is that they have done for the 2 weeks. Because they are asking for 2 more weeks, which on the face of it seems fair, my lady. But they need to demonstrate, because now we need to focus on what is important. If to them, their success of the strike is how much deaths have occurred to the people of Kenya, they should say, okay, now we have 100 people have died, now we have been successful, or something like that. That's what makes them happy. However, they have to tell us what they have done for the previous 2 weeks, because the orders of this court must not be disobeyed in impunity. They come here humbly seeking your order. When they get there, they start saying, fooling everyone to believe that they have a legitimate cause, and fooling everyone and not obeying your orders, my lady. What would make them think we will obey the orders that you give them if they are to their benefit? So for me, the image of the court must be very clear to everyone. The court is a solid, firm foundation. Nobody wants the courts to crumble. Not them, not us. That's why they ran to the Court of Appeal. We want this court to be stable forever. You took an oath, my lady. Page 183 of the Constitution has the oath that you took to defend the integrity and independence of this court. You took that oath. I took my own oath. The doctors have taken their oath, which clearly they are not serious about. Because when you look at their oath and their conduct, they are at variance, my lady. But having said that, let them demonstrate to us and the entire court what they have done for the previous 2 weeks that you gave the orders to, and then what they want to tell us they will achieve for the next 2 weeks for us to take them seriously. Otherwise, let us ensure we create an environment that is conducive for negotiation. How do we do that? We call off the strike. My clients, I could advise them, because it's my duty, to call off any threats that they have put in place. Then let's have a conducive environment for the next 2 weeks to discuss a way forward. The people of Kenya have suffered enough. If it makes anyone proud of how many people have died, people have died. Unborn children have missed a chance to live and enjoy the sunshine. And therefore, call off the strike. Let us call off the threats. Let us have a conducive environment. Let us deal with the issues. That's all I wish to say. Thank you very much.
Ashika, we are back on you. I don't know whether you want your Senator Kilonzo to say something, though he's not on record. But as a friend of the court, I'll allow you to speak.
Thank you. One of the, we are like to take caution. Two, in your discretion, your wisdom, suspended yourself to allow parties to negotiate. So I must state, as an officer of the court, that I sat in a meeting with the cabinet secretary, and his formula of resolving this crisis was to deal with the CBA clause by clause, which would result into a return to work. That is demonstration on his part of good faith. Now, that is that good faith that will come back to you and say, Your Honor, we have something that can cause these doctors to go back to work and everybody. It will most likely, Your Honor, most likely not solve everything simultaneously, because there are many parties, including the salaries and the administration, who are involved. So, Your Honor, my request to you, again in your discussion, the similar discussion that you used to suspend this sentence, and by virtue of this contempt of court order act, which came into force immediately after your order, unlike my colleague, your discretion to review your order is as wide as it can be, provided, Your Honor, you are convinced and persuaded that there is no deliberate action on the part of your order that you have made. And there isn't any deliberate action to first ensure that your order is not complied with, because you were alive to the fact that there were negotiations going on and you suspended the session. Nothing will happen in the next 2 weeks, Your Honor, if you review your order. It's not a contradiction to give an order, suspend it, and review it. You can do it, and therefore I'm pleading with you, Your Honor, today to allow, in the spirit of negotiations. I've told my colleagues that negotiations are negotiations. They are without prejudice, and therefore to allow without prejudice negotiations where you don't take firm positions, Your Honor, even you will provide this country today with some element of comfort that everybody should take action, whether it's a council of governors, whether it's a cabinet secretary. They have an equal responsibility like the doctors. The cabinet secretary's responsibility under the constitution is not less than that of the doctors. The council of governors and the governors have taken an oath similar to the ones the doctors have taken. And therefore, Your Honor, I will seek and I'll ask you that if they need to respond, they can respond. Meanwhile, your order lapses. Review it, allow them to respond. If there's going to be a report, we'll give it to you in the manner that is prepared. And thank you for allowing me to address you.
My lady, in response to what counsel presented, indeed, my lady, if you look at the application is supported by the affidavit of the Secretary General of the Union. That affidavit has attached to it or annexed with minutes of meetings between the parties. So it clearly demonstrates that the parties have been complying with that order to proceed to negotiations. It's unfortunate that councils have not looked at that, but it is clear and inspiring who attended those meetings. The question that should have been answered by council at this particular point is whether they're willing or ready to proceed with the application, whether they seek time to proceed with this application. But in answering that question of your discretion in reviewing your order, my lady, that discretion, I believe in my mind, can only be exercised after this court has had an opportunity to look at the application. So your discretion can come after this court has had an opportunity to look at the application. As we stand, the court has not had an opportunity to look at that particular application. So we therefore just request that this court proceeds and mails this application for review. If they require time to put in the appropriate responses, we grant that time. There's no prejudice where we visited on either party by allowing this application to proceed. My lady, the position will still be the same. The sentence is still there in force. Suspension does not mean that you have, in effect, completely gone back on your order. It is still there. The essence of this application is just to request that in the same way that you granted that to the suspended sentence, we proceed and finalize on the issues that have been dealt with. Because a substantive part of the issues concerning that CBA have been dealt with at those meetings between the parties.
Mr. Masasa, I can see you reaching to say something. No, you don't have a right of reply.
Yeah,
but she indicated that you whether you are
Yes.
I had Ms. Akuna say she got the exam, which means she's not really ready to proceed. I've had Umana say that she's unable to give those orders that have been sought. Masese, we had observations, and I had you say that the orders of the court should be. Let me hear from you.
Yes, I think we need to clarify what my senior colleague, Senator Velosa said, that we never get a CBA and we have a return to work from it. And it has never been that in industrial relations. When it comes to management of strikes and all, what happens is you have a return to work formula. Now, that is the return to work formula includes the issue of how you are going to negotiate. But right now, if we were to be very honest to Kenyans, we'll be doing one thing. We'll be saying, now that we are unable to have a return to work formula out there, we can have a return to work formula in that file, right? Without actually going to this application. It's a very simple way of getting out of it. We have a return to work formula in that file. Let's call off the strike, one. Secondly, all the threats that have been issued by the Council of Governors, the restraint. Secondly, within a period of maybe 2 weeks, we come back, right, to report on something. But we cannot say that we have to negotiate a CBA, then we got. The problem again we have is what you were misquoted, my lady, by saying there is no CBA. You didn't say that. You didn't say there is no CBA. My lady, what you said was, it has not been registered. That's what you said. And anybody who misquoted the court to be saying, because this is what you usually do, that there is no CBA, I think that is misleading the public. What you said was, it has not been registered. My view, my lady, has been, and my colleague, that there's a document, right? It's only that it's not been registered. That is the only problem we have. How do we do it? There are so many ways of doing it. Now, the prejudice that this will cause is that people will continue to suffer. That's the prejudice. This is not about money. I cannot suffer prejudice because you compensate me with the costs, as we had in the legal journal. No, it's about the lives of Kenyans, right? And all of us, I can see Senator Omar is here. All of us, it seems we are now willing to have this. And if the court, if my colleagues who are saying vacate the orders, they respect that you have given the orders and they know their orders. My lady, there is nothing again wrong by them saying we want to obey your orders that you issued by calling off the strike for this period, but we want the protection of this cost in terms of how we are going to negotiate and within this period. If within this period the government and the multitude referral are not able to resolve, then we go back to the strike, right? That's the only way we can resolve it, because we put timelines for that issue. We put timelines for that kind of negotiation. And now that stakeholders have come in, the Senate I think is here. It's only that we don't have the Parliament. The Senate is here. We have LSK. LSK has come in. I understand my colleague was saying LSK is coming in to mediate. The gravity of this matter, we understand. But the way we are approaching this issue, we are too casual. That's the problem. We are too casual. We are capable of resolving this issue. We have the machinery, we have the capacity. This is not the first time we are experiencing this kind of crisis. But we are not being given that chance by the other party. That is the problem we have now. And they spread it. I cannot proceed with this application because in the first place, the orders, you see, there's no audience in the first place. I don't know why we are engaging ourselves in this kind of tricks. We should be addressing a different issue, my lady, the way I've said. Can we go out with the Senate and my colleagues here? We have a return to work formula. We come and report it so that it's managed from here. We go and call off the strike. First, you cannot negotiate in a strike before you call it off. One, we are negotiating with people of disobeyed the court order. On our part, we are saying we are going to do that. We are going to negotiate with people who disobeyed the court order. But they should also be able to do the same thing. They say, I think we have pushed to the point. Now that we are here, can we have a clear guideline on a return to work formula? The CBA is there, but it has not registered. Some things have to be done on that panel beating on that CBA. This is not the first time we are talking about a complicated CBA. This was not a complicated CBA. Very simple. My lady, if I'm given 2 days to work on this CBA, I can produce them a very nice document. That's what I've been doing for the rest of my life. And I don't know why they're saying this is a complicated thing. It's not complicated. It's a very simple issue. Thank you.
I'll just hear you for a second.
For a second only, my lady. And also just to be sincere about the process. There's a lot of misinformation as well. Because when they say, when Planet, the senior senator, was talking about the issue of CBA first and then return to work formula, it's an anomaly. The CBA, as we speak, has been stayed by the Court of Appeal. Has been stayed by the Court of Appeal, and that's not how it works. So if we're talking about maybe time to respond, then let's agree on obedience of the orders we issue, and then we can come at an earlier date and put in responses, and thereafter we can discuss the issue of a further 2 weeks, because the minutes they claim to have attached, it's just 1 minute, one meeting which really doesn't go to the gist of the issue. So in our view, if we can agree on that, if they're able to call off the strike even now, then let's discuss our way forward. But otherwise, let's obey your court orders, let's put in our responses at an earlier date, and then we hear them. We are ready to deal with the issues that arise.